Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is an attorney from Campbell, California, William Mahan. And Bill has his law office, as I said, in Campbell, California. He's been practicing law for 30 years. Bill has a master's in taxation degree from Golden Gate University and a JD degree from Santa Clara University. His practice focuses on estate planning, probate, and business planning. So welcome, Bill. Thank you for joining me today.
Thank you.
Before I get started, particularly on the topic we're going to be talking about today, which is tax and financial considerations of holding title, I want to caution our viewers to seek legal advice and remind you that Bill is a California attorney. I am a California CPA, and so we're talking about California laws here, and the laws can be a little different from state to state. For example, California is a community property state, and even the community property rules, I've learned, are different from state to state. So you really do need to get advice from a local attorney for yourself. But this maybe will provide some highlights of some issues, of things for you to think about, and then you can ask additional questions about them. Okay. So Bill, let's get started with the first question. What are some alternative forms of holding title to property?
Well, there really are a lot of different types of title that people can hold. Let's just talk about the most common types, and we won't be able to go through the details of all the differences, but each type has some differences. For individuals, there's the separate property, so you hold title as separate property, as sole and separate property for an individual.
Right.
You can have a group of owners of property, and you can have, could be tenants in common.
Okay, it's like undivided interests.
Yeah, they have equal right to use the property. Their interests are undivided, which means they don't own a 10% interest in the property they own. They might be asked to a 10% undivided interest, but it's as to the whole property. So they have some rights with respect to the whole property. Another very common form is joint tenancy.
Yes.
And joint tenancy title could be held by really anybody. It doesn't have to be spouses or parents and children. It could be anybody.
Okay.
And what's significant about that is if it's worded correctly, it would be joint tenancy with right of survivorship, and that allows the people to transfer ownership of the property. If some of the owners die, it passes on to the surviving owners without having to go through any change of ownership or any probate or anything like that. Mm-hmm. There's also community property, which is a form of title. And that is generally husband and wife, because husband and wives can have community property and other unrelated people can't, unless they are registered domestic partners.
Right.
But so you're either spouses or you're registered domestic partners, and then you can have property held as community property. Mm-hmm. And there's a newer form of that type of title, which is called community property with right of survivorship, which we'll talk about in more detail a little later, but that's fairly new, and it's a useful way of holding title. Then there, of course, are a lot of different ways people own property, and they might have them in their limited liability company, and the title is held by the limited liability company, a partnership, even a corporation, which is usually not preferred for tax reasons, but possible. And then also a lot of people hold title to property in trusts because they set up trusts, and then they transfer the property to the trust, and it might be a revocable living trust, in which case they're trying to avoid probate by putting the title there, or it might even be a gifting trust or an irrevocable trust, some type of trust that the real estate is owned by the trust and is no longer owned by the people transferring the property to the trust for various reasons.
Right.
So that's just sort of an overview of some of the most common things you'll see.
Okay. And when we talk about title, and of course the main thing that we think about is real estate, because that's the big asset for many people, but you have a title for your bank account, you have a title for your brokerage account, and so forth.
Right. The titles I was talking about are basically real estate titles, but just about anything that you can have, like a bank account or a brokerage account, also has titling. And again, it can be those types of titles as well, joint
Yeah.
tenancy accounts, it can be community property accounts.
Mhm.
There also are, I mentioned trusts, but there are some special types of accounts that are designed to pass property on to people after the original account, the person who opened the account after they pass. So those are called taught and trust
Yeah.
accounts or payable on death accounts, those kinds of things.
Yes, yeah. Okay, now, how do people try to bypass probate using title?
Well, I mentioned a couple of things before. One of them was joint tenancy with right of survivorship.
Right.
And that's a very common way for people to try to do that. Now, estate planning attorneys generally don't like joint tenancy very much for lots of reasons, which we'll get into. But particularly for married couples, it's not considered to be a great way to hold title most of the time because it has some other problems, that we'll talk about again in some more detail. But that's one of the most common ways that it's done, and you'll see if you look at deeds, I'm sure you've seen a lot of deeds, and it's really very common for husbands and wives to own property as joint tenants with right of survivorship.
Right.
It's becoming more common for them to own it as community property with right of survivorship because, as I said, this is a somewhat newer version of title and better in several different ways if you want to try to avoid probate by how you hold title.
Right. And then another one that we mentioned was the taught and trust idea.
Right.
So on those, you're saying that after I pass away, I'm sort of holding it in title for this person. During my lifetime, I own it, but then it will pass to them automatically without probate.
Yeah, there are certain assets that do not pass through probate and payable on death accounts because anything really that has a beneficiary designation.
Yeah.
So life insurance policies, most annuities, retirement accounts, those pass without going through probate most of the time if you name a named beneficiary.
Right.
You need to be careful again about how you do that, and you need to be careful about how it's worded, but those assets do not have to go through a probate when a person dies.
Right. So what is happening there is that these are contractual type of obligations or whatever, and so because you've designated a beneficiary, it doesn't need to go through probate. Okay, so what's the biggest mistake that people tend to make relating to title?
Well, there really are a lot of mistakes people make. I mean, when you see the way documents, deeds and things are done by people who try to do it on their own, it's just sometimes awful. I'm sorry to say that, but you just realize that they didn't understand what they were doing, and it gets recorded. You take it to the recorder's office, they'll record it. But probably the most common mistake is this idea that you can pass your estate by right of survivorship, particularly with children or other beneficiaries, other than a spouse, without having, you're doing a probate avoidance plan with titling. The reason to me, that's not really a plan. That's just kind of a hope.
Okay.
because people don't necessarily die in the order that you would anticipated that they would. So if you have a surviving parent who puts her children on title with her as surviving joint tenants, thinking they're going to be the survivors, and then the children, one or more, pass away and the parent ends up being the surviving joint tenant, you haven't accomplished anything with that. That hasn't accomplished any kind of estate planning. The grandchildren that might have been the next in line to receive that property aren't going to necessarily receive it, certainly not without probate. So, it's just a mistaken idea that a lot of people try to exercise, which is, we'll avoid probate. We don't have to pay for expensive estate planning. We'll just use a deed or a titling document to avoid probate.
Yeah. So